Hey, Angela Langlotz, trademark and business law attorney here. And yesterday I discussed descriptive marks, merely descriptive marks, and I used the Maserati Quattroporte as an example of that. And my friend Ben Perry, who I'm tagging in this post, asked me a question or made a comment on the video that indicated that maybe I didn't do a very good job of describing or explaining descriptive marks. So I'm going to try again. This is round 2 about descriptive marks. So one of the things that I want you to understand is that we evaluate whether or not a mark is merely descriptive, that's the term we all use. We always evaluate that in context of the goods. For example, and it doesn't really have much to do with whether the word is commonly used in English or not. For example, Jaguar, right? So Jaguar is a brand of car, and Jaguar is also a word in the English language. Now, Jaguar suggests certain things about the goods. You know, Jaguars are sleek and fast and sexy, so the word Jaguar, when applied to cars, suggests a car that is sleek or fast or sexy, and maybe all those things, but it doesn't actually come out and describe, like you can't say, oh, the car is Jaguar, right? You can say that the car is a Jaguar brand car, right? But what my point is that the word Jaguar doesn't describe the goods, whereas Quattroporte, when you translate it into English and it means 4 doors, it actually does describe something about the car. The car has 4 doors. So if we say that the car is a quattroporte, it's got 4 doors, and that's what makes it descriptive. Let's give another example using a common English word, apple, right? Again, in the context of the goods, is apple, as applied to a store that sells apples, the fruit, is that descriptive? Yes, you're describing what the store is selling, okay? So if the store sells apples and you're trying to register a trademark for grocery store services for apple, that's not going to fly because it's merely descriptive of the goods that you're selling. Contrast that with Apple as applied to mobile phones and electronic goods and electronic equipment. Yes, it's a word in English, but just because it's a word in English doesn't mean it's describing the goods. Apple doesn't describe the goods at all. The goods are computers and computer peripherals and cell phones and tablet computers. It has nothing whatever to do with apples. It's just a word. We call it an arbitrary mark that was arbitrarily chosen to represent those computer goods. The question of whether something is merely descriptive also has absolutely nothing to do with whether other people are using that mark. Now keep in mind, not everything that people put a TM by is actually registrable as a trademark, nor is it always capable of serving as a trademark. You can put TM by anything you like. That doesn't mean that you can actually use that as a trademark. I could sell apples and put Apple TM by my store, but I can't enforce the right to use that because a court, if it's a common law trademark, a court would say that's not capable of functioning as a trademark. It's merely descriptive of the goods that you're selling. Likewise, if I attempted to register Apple for apple selling services or my fruit stand, the trademark examiner would say, no, that cannot serve as a trademark. That is merely descriptive of the goods that you're selling, and we're not going to give you a registration. Refused, okay? So just because someone else says they're using it and put a TM behind it, or they lie and they put the circle R behind it when it's not registered, that bears no, it's not part of the merely descriptive calculus. It's not part of that at all. So Ben, you mentioned that no one else was using your trademark and that your trademark wasn't descriptive. Those are two completely different issues. They don't have anything to do with one another. A mark is merely descriptive, and if it describes the end use of the goods or the user of the goods or consumer of the goods or the goods themselves, that's merely descriptive. Whether or not other people are using it is not part of the calculus. Whether or not people are using it is, however, part of the confusingly similar calculus, which is what we use to evaluate whether proposed marks that have applied for registration are too close to other marks that are already registered. So I hope that helps clear up some of the confusion. I'm sorry if some things that I said yesterday confused some people. I hope this clarifies. And if you have further questions, you can find me on Facebook at facebook.com/TrademarkDoctor. And if you like my page, it seems like I've got something in my eye. If you like my page, you'll be notified every time I go live. And if you comment there and ask me a question, I will answer that in a future live. You can also find me on the internet at TrademarkDoctor.net. And you can look at the whole video library there. You can schedule a consultation with me if you like. So I am available to answer your questions, and I will see you tomorrow. I go live here every day on Facebook.